Jefferson County Court at Law number 2 is now in session. The court is in session and calls number M312164. The case is styled the State of Texas versus Kimberly Reed. Let the record reflect that Ms. Reed is present in court with her attorney Jack Lawrence. Let the record also reflect that the state is present in court with Assistant District Attorney Erica Porter, sitting first chair, and second chair, Assistant Criminal District Attorney Andrew Hoover. We also have present Mrs. Haley Simmons. Let the record reflect that the court has before it a motion to quash. The court has in its files two motions to quash. First motion to quash is titled Motion to Quash, Set Aside, or Alternatively to Dismiss the Information. Second motion to quash is titled Motion to Quash and Alternatively to Set Aside or to Dismiss the Information number 2. Was that correct, Mr.
Yes.
Lawrence? Okay, and both of these motions were filed by Attorney Jack Lawrence. State, did you get copies of both of these motions?
I did. I've read over both motions.
Okay. Defense, are you ready to proceed?
Yes, Your Honor.
And State, are you ready to proceed?
We're ready.
Okay, y'all may be seated. Okay, Mr. Lawrence, you filed these motions. You may go forward.
I'm having trouble hearing you, Your Honor. What was your question?
Mr. Lawrence, you filed these motions. You may go forward.
All right, thank you, Your Honor. I'm going to start with a brief opening that will cover basically both the motions to quash. And I'll also mention it is supported by the probable cause affidavit, but we'll get to that. Everything heading up to and the arrest itself all occurred in defendant's front yard curtilage area, which was her apartment in Homestead for at least 8 years. This was somewhere in around the middle of that 8 years, maybe a little on the early side. Ms. Reed did nothing to physically interfere in any way with the two police officers in their postures prior to arrest. There was no physical reaching out or anything. All of her spoken words were aimed at finding out what the police were doing there. And this is confirmed by the probable cause affidavit. She was engaging only in free speech as protected by Article 38.15D and the First Amendment. 38.15 is the resisting arrest statute. And incidentally, it says that free speech is to be allowed as long as basically it's implying that as long as there's nothing physical, it's fine. Secondly, because the defendant came to her front door and porch area to ask most of her questions, she was there for about 15 minutes asking what's going on, basically, and then continued into an area below the porch. When she didn't get adequate answers, a warrant was required to arrest her, since she still was within the curtilage area. That's your Fourth Amendment ground. She also could not be arrested for interfering with an arrest where she was only exercising the rights of free speech to find out about things. That's the extent, that's a summary, rather, of the motions to quash. And we can take testimony and find out more about it. I do have a copy of one of the cases I've cited, which is Freeman versus Gore. It's a Fifth Circuit case involving a Texas situation where a person was charged with hindering apprehension, and it pointed out that the deputies did not have probable cause to arrest Freeman for hindering apprehension. And it cites other cases. I've cited it in my briefs. Now, if you would like, Your Honor, I could continue arguing motion to quash number 2 and then go to motion to quash number 1, if you'd like, or I could have Miss Reed answer some questions if you like.
Mistake.
Well, the state, okay, state wants to respond. First, I've read over both motions. What you're trying to argue seems to be incorrectly filed. A motion to suppress would have been more appropriate, or he's trying to argue facts in the case, and this is not the proper forum. Facts in the case can be argued at trial. We're not in trial. We're in a hearing to quash the information. The information is not defective on his face. And because it's not defective on his face, his motion should be denied. Also, and I'm not gonna get too deep into some of the things that he's accusing the officers of not doing. Those facts are gonna come out in trial, and that's the proper forum for the findings of fact, and not today. So we're gonna ask for you to deny both motions to quash. Based on that.
Your Honor, we can simply go with the probable cause affidavit if you like, which was filed by the police.
Now, Mr. Lawrence, your motion is to quash the information. Is that correct?
Sir?
Okay. Your motion is to quash the information. Is that correct?
Actually, the one we need to deal with is the motion to quash number 2, in particular, because the statute that she was arrested under, Penal Code Section 3815, if you look at 3815D, it says very plainly, it is a defense to prosecution under this section that the interrogation, disruption, impediment, or interference alleged consisted of speech only. And that's what we're noting in the probable cause affidavit. The policeman says she was arrested for speech. That's all there is to this on the First Amendment issue. And that's why it doesn't fly. And if you read the case law in Texas on 3815D, all of it says if there's no physical interference where she might have reached in with her hands or something, then it's speech. Basically, they imply it's speech. As long as it's speech, and then I would emphasize, particularly in our own front yard, it's protected. That's the long and the short of it, Your Honor. And I can let you see, I can submit the officer's probable cause affidavit if you like. And you can read it, or I can read it into the record.
And again, Your Honor, we would like the court to consider if counsel would like to argue these facts to the jury could be the individual to determine this, or even the judge at a trial. That's not the proper setting. And also, you're grossly misstating the probable cause affidavit.
Well, I can read the probable cause.
Well, Mr.
It comes in with about her.
Yeah, Mr. Lawrence.
This is about the First Amendment primarily.
Hold on a third. Now, basically, Mr. Lawrence, well, your motion is to quash the information. Okay, and so in your motion to quash, when we're looking at the motion to quash, the charge, it said if a motion to set aside or an exception to an information, or indictment or information is sustained, the defendant.
Could you speak into the microphone, Joe?
Okay, Mr. Lawrence. 28.04 of the Texas Code of Criminal Procedure addresses issues on motion to quash. Actually, section Article 28.05, 28.04, and 28.06. Also, 28.07 exception is that no offense is charged. And basically, I guess from what you're saying, the information does not charge your client with an offense because, as you state, speech only is, if it's just speech only in the information, that is not an offense. But I think the statute in which you read, when it talks about mere speech, as it relates to interfering with the public duties, that's a defense. The defense comes into play. The defense comes into play once the case goes to trial. The defendant can raise any defense. This is not a trial. We're talking about the face of the information. And so when the court is looking at the face of the information to determine whether or not there's sufficient language in the information to put the defendant on notice of an offense, that's what the court has to look at. And we're looking at this information, not the PC, but the information. Your motion is to quash the information. And so when we're looking at the motion to quash this information on its face, and I'll just read it. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Kimberly Reed, hereafter styled the defendant, heretofore on or about May 10th, 2016, did then and there unlawfully with criminal negligence interrupt, disrupt, impede, or otherwise interfere with Keith Bernardo, a peace officer, by verbally distracting officers and refusing to stay a safe distance from the officers as they were arresting another person while the said Keith Bernardo was performing a duty and exercising authority imposed and granted by law against the peace and dignity of the state. In this information, it not only talks about speech, but it's also talks about refusing to stay a safe distance from the officers. Okay, so on its face, it's not an information that speaks of speech only.
It speaks of what?
It does not speak of mere speech only in this information.
Your Honor, if I may read from the probable cause affidavit.
The probable cause affidavit is not in question. What's in question is, according to your motion, what's in question is the information. The motion to quash pertains to the information. And looking at this information,
I believe the motion to quash under Texas law speaks to jurisdiction, and jurisdiction can be determined, presence or absence of
Now-
jurisdiction
now
can
it-
be determined by constitutional right.
Yeah, but also in, well, I understand that. I understand the First Amendment right. I understand, 30, the defense that is in the statute, that talks about harassment. And as I mentioned earlier, the first word says that it is a defense. That's how it starts off. And so when you're talking about defenses, it's a defense to an offense. And you say that was, Penal Code Chapter 38. Hold on.
3815D,
Okay,
but that has been held by almost universally by Texas courts to be based on the First Amendment of the U.S. Constitution. Your
I
Honor.
understand that. But it is not used to quash an information.
I think
It's been, and not only that, but it's, in case law, particularly the case law that's been submitted, even if you look at Trevino, a case that you have not cited, even in that case, it talks about, the mere, speech is used as whether or not it should be included in the charge of the court. It comes in the charge of the court if, actually, depending on the, strategy of the defense attorney, it'll come into charge if the defense attorney thinks that it should come into charge. What I'm saying to you is that your motion is a motion to quash the information. You're talking about something that's defensive, which is like, it could be like, mistake of fact is a defense. It could be, self-defense is defense, defense of a third party. And so those are defenses. But when you file your motion to quash, you're saying something is wrong with this information. This information on its face does not allege an offense, and it's not putting my client on notice as to what she has been charged with. But what you're saying is that, well, what's here is speech only. And when I just read the charge, it is not just, speech only. In the manner or means that, that's used in this information.
Your Honor, may I submit that, the operation and construction of the statute, must be consistent with fundamental law. And that is why I used a motion to quash on both these, number one and number two, is because it contradicts the fundamental law of the U.S. Constitution. And this 3815D has been interpreted many times by Texas courts to be a First Amendment criteria. So if I may, Your Honor,
Now,
what I'm saying is that the First Amendment overrides anything procedural in this, where when the arrest was made, if the First Amendment said that you cannot arrest somebody simply for exercising free speech, which is what we're saying.
okay, that's what you're saying, but what I'm telling you is the information is not just talking about speech. The information also includes the physical conduct. The physical conduct in this information is the part that says she's refusing to stay a safe distance from the officers. It alleges speech and physical conduct, not speech only.
But they were within the curtilage of the house. She can.
That's a Fourth Amendment claim, and as I think counsel said, it's more appropriate to file claims like that under motion to suppress. This is a motion, this is a motion to quash. So
They have to-
where on the face of this information, it says that Miss Kimberly Reed is charged with speech only. Where is that in this information? That's what the court needs
It
to know.
doesn't have to say that, and what I was pointing out is that the probable cause affidavit does say essentially that,
Well,
signed by the police officer. who
Okay.
wrote the Affidavit.
okay, I've taken judicial notice of the probable cause affidavit. And that's part of what that affidavit says. The affidavit also talks about the physical conduct.
Your Honor, she never got that close to them. It says, to go just to the part you're talking about. I had to disengage with Robinson and stop Reed from advancing towards us.
From what?
I had to disengage with Robinson, that's her husband, and stop Reed
From doing what?
advancing towards us.
Not just talking?
That's the police officer saying that. And,
That's what this information says.
and then next it says, due to Reed yelling and advancing toward Officer Carmouche and myself, as we were trying to arrest Robinson while he was resisting arrest, and me having to disengage with Robinson to deal with Reed, Reed was placed under arrest for interfering with public duties. But it never says that she made any physical encroachment. She stayed
Physical,
on the porch, up by the porch for 15 minutes.
does it say
What are
that?
y'all doing?
Does it say that? Oh, now, those are fact issues that a jury can determine. This court, with this hearing here, is not to determine those factual issues. The jury decides the facts of the case and they determine the credibility of the witnesses. This is, this is not a bench trial. This is only a hearing on your motion to quash.
Have you looked at the authorities that we've cited, Your Honor?
That's the reason why, I looked at those authorities. And that's why I also quoted the case of Trevino. I'll just give you that site. Let's see.
Is that Trevino?
Trevino, yes. And it talks about the city of Houston versus Hill and all these other cases, but that's also cited in the brief. Wait, hold on a minute. This is it. That'll be 512 Southwest 3rd, 587.
527?
587.
587.
512 Southwest 3rd, 5. That's just, I guess you could say, one of the main cases. It talks about there are several cases that's used. Hold on a minute. So,
And I need to mention, if I haven't, Your Honor, that the person in the front yard that they were initially after is her husband. uh, Robinson. Robinson is her husband, even though they don't go by the same last name. That's her husband, and they have 3 children.
Okay. 30-15. Okay. Oh. That's- Okay.
I hope you had the opportunity to read Carney versus State.
Yeah, that was
West
that was another one that was in there.
Sorry?
Carney. That was another one. I looked at your brief and looked at these cases. That was another one.
Good.
Carney was another one.
Good.
Okay. So,
Okay, we simply base our argument, Your Honor, on the fact that the First Amendment in particular, as it would apply here, is fundamental law, which has a sort of a universal application. And it controls what the police conduct should be under these circumstances. And due to the fact it's everything's about her shouting, "What are y'all doing?" basically, and not getting physically involved, then they don't have a police, for one thing, they don't have a police power basis because she never got up within reaching distance. They don't have a police power basis for arresting her. She was just speaking. That's all it amounted to.
well, I mean,
The second thing is it's within the curtilage, is between her front porch where she made most of her statements for about 15 minutes. And then but it's between the front porch and the curb. It's definitely all in the front yard, which is curtilage. And that's protected by the Fourth Amendment, when it comes to arrest. They had to have a warrant with her name on it to arrest her, unless she became physically involved with one of the officers. It's just
State. Okay, you go ahead. I thought you was finished.
So I mean, if you're making that your ruling,
I hadn't ruled.
huh?
I haven't ruled.
Okay, that's our argument, basically.
Okay, I understand that. State, you can respond.
Again, Your Honor, the state would like to reiterate that, defense, a more proper motion would have been a motion to suppress, and a more proper form would be a trial, where the finders of fact can determine, First Amendment, Fourth Amendment issues that you're having, with this case. And this is just not the proper form. So we're asking for you to deny both motions to quash.
Okay. Yeah, this time the court will deny your motions to quash. Okay.
Okay, are you denying both motions?
Yes.
All right, we accept to the 2 rulings of the court on our motions to quash, Your Honor.
Okay. That's fine. All right, this will conclude this hearing. Okay, this will conclude the motion to quash hearing that was conducted today in cause number M3-12164, case of Style State of Texas versus Kimberly Reed.